A very warm welcome to lesson number 14. In today's lesson, we will be summarizing part 2 of the Indian Evidence Act. So in lesson number 12, we had a look at the summary of the whole act. In lesson 13, we had a look at part 1. In this video, we look at part 2, and in lesson 15, we look at part 3, right? So let's step into the lesson. So we know that the Indian Evidence Act is divided into 3 parts. These 3 parts have 11 chapters. 11 chapters have 167 sections. So that's the overview of the Indian Evidence Act. We have already discussed part 1, which contains chapter 1 and chapter 2, extending from section 1 to section 55. Now we look at part 2. Part 2, which is titled On Proof, right? And it contains 4 chapters from chapter 3 until chapter 6. In this video, we will have a closer look at these chapters so that you have an idea of what to expect when you go ahead and read them in detail tomorrow. So when we look at part 2 and start off with the first chapter of this part, which is chapter 3, it is titled Facts Which Need Not Be Proved. Now, what was the chapter immediately before this? It was chapter 2. Chapter 2 talks about the facts which, of course, either can be proved or cannot be proved because it discusses the relevancy of those facts. So relevant facts can be proved and facts which are not relevant cannot be proved. Now, chapter 3 talks of facts which need not be proved, which means the court says that if there is any such fact, well, you need not prove it. There's no need for you to go ahead and show evidence for it. I'll talk about it in detail. Just wait for a moment. So then we look at chapter 4. Chapter 4 talks about oral evidence. We know that there are 2 kinds of evidence, oral and documentary. So if there's oral here, we understand what the next one will be. The next one, of course, is documentary evidence. Chapter 5 relates to documentary evidence. And then chapter 6 talks about what you do when you have both oral and documentary evidence for the same thing, right? So that's what you can expect in this part. Let's go ahead and see it in a little more detail. So talking of the number of sections in these chapters and the section numbers, you can see that chapter 3 has 3 sections from sections 56 to 58. Chapter 4 is even smaller. It has just 2 sections, section 59 and 60. Chapter 5, quite long, 61 to 90A, more than 30 sections. And finally chapter 6, around 10 sections. So we don't really need to know all of them, but there are some important things, and in the remainder of this lesson, I will acquaint you with these chapters and as to what you can expect in them. Let's start with chapter 3. So chapter 3 is quite small, so it won't take long for me to explain that to you. It basically contains 2 points for you to remember. It talks of facts which need not be proved. In other words, the court says that, okay, if there are such facts, you needn't prove them. We don't want evidence for this, right? So the first kind of facts which need not be proved are those for which the court takes judicial notice. What does that mean? The court says that we already know this. We don't want you to prove this. For example, what is the map of India? Right? Should someone go ahead and say that, okay, this is Delhi, here's the proof of this being Delhi, this is the map of Ahmedabad, this land is mine, this in Ahmedabad. The court says, well, let's not go there. You need not prove the maps of India. Now, if somebody wants to prove that, okay, this is section 502 of the IPC, the court says, no, let's not even get there. The laws of India also need not be proved. We have taken judicial notice of it. So no evidence for this is required. Right? There is no dispute, there is no evidence required because the court has already taken notice of it. Right? What is the second type? The second type is facts which have been admitted. What does that mean? Let us say both parties agree on a certain fact, right? So let's say A says that B has taken 500 rupees from me, and B says, yes, I have taken 500 rupees from him. Now the court says when both of them agree on a certain fact, then there is no need for evidence, there is no dispute. So facts that are admitted need not be proved, which means that for these, no evidence is required. So this pretty much sums up chapter 3 for you. There are certain facts of which there is no need to give evidence, The facts are basically of two kinds. The kind of facts that the court takes judicial notice of. Second, the kind of facts which have been admitted by the parties. Alright, we look at part 2, chapter 4, which deals with oral evidence. We've seen what oral evidence is in lesson number 10. Oral evidence is basically the testimony or the statement given by a witness before the court. That is oral evidence. Simple. This chapter has two sections, small chapter, and I would want to discuss just 2 points with you with regard to this chapter. The first is, when can oral evidence be given? When can you give oral evidence? Which means, when can a witness come and talk before the court? The answer is, it can be done for everything, for every kind of fact, except the contents of a document. Which means that a witness can come and depose and can testify about any matter except the contents of a document. Let me explain this to you. Let us say there is a certain document and it has some contents, right? Now, if there is oral evidence of the contents of a document, it means a witness will now speak about what is given in the document. Now, isn't that absurd? You have a document. Why do you want a witness to speak about it? Just get the document. Which means you're saying that oral evidence can be given for everything except the contents of a document. So I hope you get this point. Simple point. Second, and a very important rule, which is, how should oral evidence be given? Right? Oral evidence has to be direct. In other words, if it was something that someone has seen, then the person who saw it should come to the court to speak. If it was something that was heard, the person who heard it should come to the court to speak. It cannot be hearsay. In other words, you cannot come and talk to the court about something that someone saw and he told you, you tell someone else, and now this person goes to the court. That's not how it works. The oral testimony, which means oral evidence, needs to come from the horse's mouth. So these two things are the rules that you need to know about oral evidence, which are contained in chapter number 4. And with this, you get a fair idea of what is contained in chapter number 4. We can go ahead now to chapter number 5. So as you can see, chapter number 5 is relatively long. So we will spend a little more time on it, learning some terms that are important for our understanding of this chapter. However, not all sections require to be learnt, because many of these sections are not so important or critical to our understanding of the law. Okay, so let's start off with a few terms. The first amongst these, and perhaps the most important, primary and secondary evidence. You definitely have heard these terms. Primary evidence is basically the document itself, which means the original document. Fairly simple. What is secondary? Secondary evidence is a copy. What kind of copy? Well, it could be a handwritten copy. So you look at something and you copy it down, like how some students do it in the exam. That's also a copy. Or it could be a photocopy, or it could be a photograph, or it could be a carbon copy. So there are various kinds of copies, but the thing that you need to know in general is that primary evidence is the document itself. Secondary evidence is some kind of copy, right? Let's go ahead. Now, when we talk of documentary evidence being divided into primary and secondary, what is primary evidence is given to you in section 62 of the Act. Okay. Now, when you think of primary and secondary, which one do you think is preferred? Do you want the original or do you want the photocopy? Obviously, the primary evidence is preferred, and that is what is given in section 64, that there's a preference of primary as compared to secondary. So we prefer primary evidence that is given to us in section 64. Likewise, what is secondary evidence given in section 63? And what are those situations in which you will accept a photocopy? See, sometimes you can't get the original and therefore you accept the photocopy. So what are those situations? What are those conditions? Those are given in section 65. So you get an idea of what is given here until 65. We've done half the chapter already. Not half the chapter, we've done a good part of the chapter. Having understood the difference between primary and secondary, we now look at two new terms, right? Private documents and public documents. Now, let me first talk about private documents. So let us say I go to a shop, I buy, say, a musical instrument, and he gives me a bill of 10,000 rupees. Now, that's a document. What kind of document is it? It's a private document. Let us say I write a letter to somebody. What kind of document is that? Private document. A and B enter into a contract and write the terms down. What is that? Private document. Simple. So something which is between private people, privately owned. What is a public document? Now, a public document obviously is something which is not private. Let me give you an example. Let us say if there is the certain registry, okay, of land records. So there's a record which is there with the government. That is a public document, right? For example, now if you want to get your trademark registered, again there's a registry for that. Someone has the document, the record. What kind of document is that? It's a public document, right? So something which is with the state or the government, the original copy of which you cannot have. The original is with the government, therefore that's a public document. Very simply explained and understood. Now, in case you're curious, you can go and have a look. Public documents, section 74, private documents, section 75. And now I want to talk about certified copies of public documents, which are given in section 76. Now, you might have appreciated the fact that public documents, the original copies of them, well, the original forms of them, cannot be with you, right? You can perhaps only get a copy, because can you really get the original which is being maintained by the state and by the government? No, you can't. So it is required at times for us to get a copy, and a certified copy is a verified copy. You can go ahead and see this. I'm giving you the numbers here to tell you that now we've crossed the 60s and now we're into the 70s. So we've got a fair idea of what is contained in this. Let's go ahead. So now we look at the remainder of the provisions, right, of documentary evidence. So when we look at sections 79 to 90A, they basically deal with some presumptions relating to the documents, right? Now, it's not important for you to know them. You can go and see them whenever required, but I'll just give you a few examples. For example, section 79 contains a presumption as to the genuineness of a certified copy, right? So the court presumes that when you present a certified copy or a verified copy of a public document, the court presumes that it is genuine. Well, that's one of the sections in here. Likewise, the contents of the gazettes, newspapers, etc. are presumed to be right. Likewise, you have a presumption relating to a document which is 30 years old. You can go and have a look at it, section 90, in case you're curious. Finally, there is one important thing that you need to remember within documentary evidence, which is the kind of documentary evidence that was introduced lately because of the electronic media, which is the electronic evidence. So the electronic records are also dealt with in the chapter relating to documentary evidence. So you must have heard of section 65A and 65B, which deal with electronic records and the proof of electronic records, right? And of course, there are these provisions that are supplemental to the existing provisions. Like, for example, we saw 81, right? 81 talks about newspapers and gazettes. So if there is an electronic gazette, well, 81A is for the electronic gazette. Likewise, we saw section 90, which was for the documents which have been executed 30 years ago, and 90A deals with electronic records which were executed 5 years ago. So you get the idea, it's like a parallel. So whenever you see something like an A or a B, generally that deals with electronic records in the Indian Evidence Act, because electronic records have been added later on, obviously, because the Indian Evidence Act is an act of 1872, and the IT Act in India came about in 2000, the IT Act, and that brought about certain amendments because of which electronic records had to be considered, and you find those provisions also within this chapter relating to documentary evidence. Let us say, to start off chapter 6, that for a given fact, you have both a piece of written evidence as well as a piece of oral evidence. Which one do you trust more? Something is given to you in writing, something is said to you orally. Which one do you trust more? Do you trust what was spoken, or do you trust that which is written? Perhaps in most cases, if you are like me, then you trust what is written. So, when there is a document, what do we do with oral evidence? Do we accept it or do we not accept it? Do we completely dismiss the oral evidence? Well, sections 91 to 100 talk about what is done when you have a document for a certain fact and you also have oral evidence. So should you take the oral evidence or should you not take it? So the provisions basically deal with the question of whether you will accept oral evidence or not. So the general norm here is the exclusion of oral evidence by documentary evidence, which means that if you have documentary evidence, you exclude the oral evidence, which means that generally you do not accept oral evidence when there is documentary evidence. However, there are some cases in which it becomes important for oral evidence to be accepted. I will give you a summary of some of the sections now, so you get an idea of what these provisions are. So let us look at an example when oral evidence is not accepted first, which is basically the general principle given by chapter 6. So for example, let us say section 92 says that when a contract has been written down, right, the terms of a contract or any other disposition of property have been written down, then oral evidence will not be accepted for that. Because you have a document, if there's any question as to the contents of that contract, just bring the contract. Why do you want to have oral evidence for it? Likewise, suppose there's a certain document and the language of that document is clear. Then we don't want someone to speak about it. Let us just read the document, right? So the exclusion of oral by documentary. However, there are some cases in which you might want to accept oral evidence. For example, let us say there are some provisos to section 92. So as you can see here, there are some provisos given in there. You can go and have a look if you like. Those are some cases in which you would accept even oral evidence for the written contract, right? And likewise, suppose the language is ambiguous. So you saw that in 94, if the language is clear, don't get oral evidence. But what if the language is ambiguous? You're not sure as to what that means. In such a case, you will allow a witness to speak about it. So there are some cases in which oral is not accepted, some cases in which oral is accepted. This basically deals with what you can expect in chapter 6. Well, so I hope that in a fairly short span of time, we've been able to acquaint ourselves with the whole of part 2 from chapter 3 to chapter 6. It talks about what kind of facts need not be proved, what oral evidence is, some things about documentary evidence, and also what is to be done when you have both oral and documentary evidence for a given fact. So I hope this lesson was of use to you. Thank you for your patience. Good day.